Okay, we are back. Anything we need to take up before you call the next case? You may call the next case, please.
Harpeth, Crest, HOA versus Cypressbrook, Coley, Davis General Partnership.
Our first non-educational case. Or perhaps this is an educational case. I don't know.
No. I think this is a good old-fashioned property rights case, Your Honor.
Okay.
Your Honor, I'd like to reserve 5 minutes for rebuttal.
All right, sir.
May I begin? Jason Holloman here on behalf of the plaintiff appellant, Harpeth HOA. Your Honor, I want to begin by sort of breaking this into what I see as 3 sections. Section 1 is whether there is an easement at all that exists and benefits defendant. And there have been arguments made for express easement by both deed and by plat, and we believe that neither of those exist. And I'll focus on that for a few minutes, and then I think the real issue that we have is the state of the law in Tennessee as to overburdening. And even if this court were to agree with the trial court that there is an easement, we think it's clear that under recent case law, particularly Region, even though Region found that there was no overburdening, we think that a read of Region really benefits our position in terms of whether overburdening exists. And then finally, if we get into the overburdening question, we also believe that this comes before you on an appeal from a motion for summary judgment, cross motions for summary judgment. We believe that we are entitled to summary judgment based on the facts that are agreed upon, but that the reliance upon facts that are either disputed or disprovable that the defendant relies upon would require this court to remand it for an evidentiary hearing. So as to whether—
Is that as to both issues, counsel, whether or not there's an easement and also whether or not there's an overburdening?
Yes, Your Honor. We believe that there are issues as to the facts surrounding the deed language that is relied upon, the plat, because there is a surveyor. Surveyor plainly says in the plat issue that he is his findings are subject to a title search. And none of that is agreed upon by the parties as to the underlying facts related to that title search. Then as to overburdening, as we pointed out in our initial brief, there are specifically facts related to the level of ingress and egress that may occur through this purported easement if this property was developed out. Some of those are disputed, and some of those we believe are directly refuted and inconsistent with the record. I want to begin with the express easement, and the language that is relied upon by the defendants is in a deed that is actually not anywhere in the title search of defendant. There is a line in a deed that is 2 deeds back from my client, but it's important to note that in the intervening deed, there is no reference to anything about a gravel driveway. There is a reference 2 deeds back that says it is subject to an existing gravel driveway for adjacent parcels per a survey. The survey is unrecorded, so the exact details of that gravel driveway are completely unknown, at least to someone conducting a title search. And the Noble case, which is referred to by both parties consistently in this litigation, says that to create an easement by express grant, there must be a writing containing plain and direct language evincing that the grantor's intent to create a right in the nature of an easement rather than a license. And we assert that the language that is in that old deed, and only that old deed, is much more in the nature of a license than it is an easement appurtenant. There is no reference to a specific party, and there is no specificity as to what its scope of use is. More importantly, that gravel driveway was actually removed by the subsequent property owner, the owner that had that before us. So that leads us then to, was there a deed created by plat when the developer of my client's subdivision built out that property? And the only note on the plat that's relied upon by defendants refers to a 50-foot ingress-egress easement. It doesn't identify for whose benefit. It doesn't actually specify the exact parameters of the easement because, again, it relies upon a surveyor that says it's subject to a title search. And he says he doesn't have that title search at the time. What we put forward in the brief is that what does exist and what we don't dispute is that there is, in this exact location, a recorded Harpeth Valley Utility District access easement for some of their infrastructure. And we believe that is the easement that is referred to on that plat and nothing to do with the defendant. So at a minimum, that is a factual dispute that we think is appropriate for trial if this court was to decide that there was an easement based on plat. That is clearly a disputed fact. And that brings us then to the overburdening issue, which, as this court is aware, there are sort of varying opinions that have been issued as to at what point you have overburdening of an easement. But the one that I want to dwell on...
Before you go into that, let me
Yes,
ask
ma'am.
you a question, just for clarification. Is the Cypressbrook property landlocked but for this purported disputed easement?
Well, I think that's almost a matter of dispute as well. There is access that is being built to another public right-of-way. Requires a bridge construction there, but that is a feasible, accessible possibility. But the court.
But for building a bridge, then let me ask you that. But for building a bridge, is this parcel of land landlocked?
At this time, but I will say that easement by necessity was not something that the court relied on. I think there are arguments and discussions about easement by necessity and what the scope of that would be, but that is not the basis of the court's decision. What I want to point out, most particularly in the Region case, is that the court in that case determined that there was, in fact, what is called normal development. In other words, the scope of an easement can be expanded if the dominant estate engages in normal development. And in that particular case, what had happened was the expansion of use occurred within the existing zoning of the property. There was a conditional use, special exception permit use, named differently in different jurisdictions, that was granted to allow that use, but the court made a point in saying that it was still within what was permitted under the current zoning uses. In the metro zoning scheme, we have uses under existing zoning that are permitted by right, some that are permitted with specific conditions, and some that are permitted with special exception. What the court made a note of in footnote 8 is that there were other more intense uses that may not be normal development that were actually still allowable uses within that particular rezoning category. And I bring all that up to say that where exactly we draw that line may be a matter of discussion. But I think that in this particular case, we are well beyond that line in any set of facts, because this property did not develop out under existing zoning, under normal development. It not only required a rezoning of the metro government, it actually required an amendment to the community plan. And if this court is familiar with land use law, in order for the Planning Commission to give a positive recommendation, there is a community plan that says, here are the existing zonings now, but what is appropriate for rezoning in the future? And so not only was this property not zoned for the use that it is now planned to be used for, the community plan didn't even suggest that that was an appropriate possibility. They had to amend that community plan and actually increase what's called transects. They had to increase the intensity of use allowed in the land use plan, and then rely upon that to get a rezoning. So when I look at footnote 8 in the Region case and say, is this within normal development? I think that it's clear that it is not. And when you look at the Gatlinburg versus Birchfield case that's also discussed in many of these opinions, in that particular case, the court noted that where the airport authority would have to go back and obtain approval from the planning commission, that was beyond normal development, beyond what was allowable and considered under the original scope of the easement. So for that reason, we believe that even if this court were to determine that there is an easement, it is certainly overburdened. It will go from 22 allowable residential units under current zoning to 417 units if this were permitted. Thank you.
Thank you.
Good morning, Your Honors.
Morning.
Peter Sayles, on behalf of the appellee. I think that would it be appropriate to discuss some of the facts in this case. Dr. Fussell first bought the property, which I'll call the Fussell property, in 1982. The Fussell property was accessed by crossing the property owned by Mr. Newsom, which is now the HOA property. In 1999, Newsom sold the HOA property to Vincent. That deed, which is recorded with the Register of Deeds office, says that it is subject to an existing gravel driveway for ingress and egress for adjacent parcels as shown on the survey dated June 18, 1999. The Fussell property is specifically identified as one of those three properties that benefited by that easement on the survey.
Considering the language you just gave us, would that amount to a utility easement as argued by opposing counsel?
Your Honor, that easement is specifically for ingress and access for the three identified parcels in the survey. So no, that is not a utility easement, sir. For 20 years, that gravel easement provided the only access to the landlocked property of the Fussells. In 2001, the developer of the property, by the name of Harpeth Crest LLC, purchased the Vincent property. The Harpeth Crest deed states, being the same property conveyed to Vincent, to Barry Vincent and Barbara Vincent, by deed from W.J. Newsom. And there is no reference to the easement in the deed that Harpeth Crest took the property from, but it directly references the recorded deed which contained that easement. In April of 2002, the developer recorded a plat for the development. That plat contained a 50-foot ingress egress access easement, which has been used since that time, 2002, to access the Fussell property.
Is that a replacement easement?
So how did that come to be? I'm going to answer your question right now.
All right.
The developer, who was deposed in this case, testified that he and Dr. Fussell got together and agreed to relocate the gravel easement. And the developer elected to relocate it to the gravel easement because there was no way it could stay where it was and still develop the houses that he wanted to develop, of which the HOA is now those houses. So the developer, and he testified to this, that the agreement to relocate the easement was recorded on the plat as a 50-foot ingress-egress access easement for the Fussells to utilize to access their property. The developer also testified that he did not intend for there to be any limitations on the use or restrictions on the use of that easement. And he specifically envisioned purchasing the Fussell property at some point and intended the easement to be utilized for that development of that property. That developer did not acquire the property at the end of the day. The specific testimony is, you had a verbal agreement with Mr. Fussell that you were going to relocate that gravel driveway in such a way so that the Fussells could still access their farm. Is that correct? Correct. And that agreement is memorialized in the plat, which we looked at as Exhibit 1, and the 50-foot easement reflected therein. Yes. He later testified, and it was your intent, at least in part, to use that easement to facilitate the development of the Fusel property. Is that correct? Correct. And with regard to the use of the access easement, Mr. Bolden, the developer, testified, to the best of your knowledge, were there any restrictions on the use of that easement? No restrictions to my knowledge, and you didn't intend for there to be any limitations or restrictions on that access, did you? Correct. So since 2002, that 50-foot ingress-egress access easement has been utilized to access the Fusel property. And since that time, it has been used for commercial purposes. There was a horse training facility there, and they averaged between 5 to 7 trucks and 3 to 5 horse trailers per day, and with an additional 10 to 20 cars on a weekly basis. Prior to closing on the Fusel property by the current defendant, Metro rezoned the property. Plaintiffs and its representatives were present at the Metro's meetings and hearings. Plaintiffs and their representatives opposed the rezoning and raised these very same issues that they've raised today associated with a supposed lack of an easement and the issue of overburdening. Metro heard plaintiff and its representatives, and it did not find these arguments persuasive and approved the zoning changes.
Does that have any effect on the overburdening argument that's being made in the trial court?
It does, Your Honor. And it does because these issues have been litigated. And one thing I just want to clarify, there was no appeal filed of the Metro zoning decision. And how that impacts this, Your Honor, is Regan, which opposing counsel discussed earlier, does discuss what normal development is. And normal development is continued development of a property which is consistent with the Metro or the zoning. In this case, Metro heard the arguments, they allowed the rezoning, and Regan holds that that is normal development because these have now been approved. The one distinction which opposing counsel tries to draw with Regan is that it was within the zoning then allowed. However, what Regan states is, in Regan, it was going from residential to commercial, and there was a commercial special exception needed, which was an exception to the zoning so as to allow the requested use. The opponents in Regan, the defendants, plaintiffs in Regan, challenged that at the Metro level. Metro granted it, they didn't appeal it. And when the court then had the case, they said, look, Metro's already approved this zoning, this special commercial special exception, so it's within the normal development. And oh, by the way, you didn't appeal the actual decision. So
was that this issue, this administrative overburdening determination that had been previously made, was that part of the trial court's analysis in the overburdening disposition?
So the trial court looked at a multitude of issues when determining the overburdening issue, Your Honor. One of which was the testimony of the developer who stated the purpose, and that's what the question is, and everybody agrees. When looking at whether something is overburdening an easement, the question is, what is the purpose at the time that the easement was created? And the case law is clear, contrary to what opposing counsel says, that the concomitant, the facts and circumstances surrounding the easement at the time of its execution is admissible evidence. And the developer has testified that he intended this easement to be utilized for future development of the Fusel property.
This is the replacement easement.
Correct. Correct. The 50-foot access.
We're not looking back to the original deed reference either.
We are not. We are not, because it was relocated or replaced by the 50-foot easement. The trial court also looked at the Metro determination and stated Metro has approved this zoning. Plaintiff was at those hearings, contested them, and then didn't appeal it. So it is now what the zoning is for that property. So that this Metro has made a determination regarding the zoning, and the use of the easement consistent with that zoning does not overburden it. So the trial court looked at the testimony of the developer who stated This was the intent and the purpose of the easement. It was not intended to have any restrictions on the use. He did offhandedly say he probably wouldn't put construction equipment on this easement, but he didn't have any restrictions prohibiting it, and the purpose of that easement was for the development. One point I want to make about the testimony of the developer, for the first time in their reply, plaintiff has argued that this information should be excluded based upon the parole evidence rule. That was never raised below. So that issue has been waived. Moreover, with regard to that, Your Honors, as I had mentioned, the case law is clear that it is exactly this type of evidence that is necessary to develop the purpose and to understand the purpose of the easement. For example, in the Blue Cross case, the Supreme Court said, in interpreting a fully integrated contract, extrinsic evidence may be used to put the written terms of the contract into context. Hamilton, the Tennessee Supreme Court noted that evidence on a party's situation when the contract was entered into may not be used to modify or vary its terms, but can be used to aid in determining the meaning given to the agreement. And even in Regan, the Court of Appeals stated, the extent of an easement is determinable by a true construction of the grant or reservation by which it is created, aided by any concomitant circumstances which have a legitimate tendency to show the intention of the party. The Bolden testimony, the developer testimony, is clear. He created the 50-foot easement as a replacement to the gravel driveway. That was the agreement that was reached between the developer and Mr. Fussell, and as evidenced by a written recording that is recorded with the Register of Deeds office. He further testified that the purpose of that easement was several-fold. One, to give access to the Fussells to their property, and two, to facilitate the future development of the Fussell property. Lastly, he testified that he absolutely did not intend for there to be any restrictions on that use.
Did he know at the time that the development would include as many as 400 units?
That the development was not yet planned at that point, Your Honor. So I don't see how he couldn't have that knowledge at that time.
All right.
The other thing, getting back to your other question, Your Honor, about what the trial court considered in determining that this was not overburdening the easement, the other thing that the trial court considered was the eventual use of that easement. And contrary to what opposing counsel says, and I'll give you the record references to this, the Metro put certain restrictions on the use of this easement as part of the approval of the zoning. As an initial matter, they have restricted the construction equipment access to an average of 5 cars per day over, I think it's a 4-week time period, until the bridge is built. And then once the bridge is built, there will not be any other access except for emergency vehicles through that use easement. Opposing counsel has argued, or the appellant has argued, that this is not reflected in the record anywhere, and that's just not accurate. It is at the volume 4 at pages 530, 536, 534, and 535. And those are the materials that were submitted to Metro, which were part of the approval process, and it was the preliminary plat that was approved. And those contain, on the Fussell property, gated emergency access. It clearly denotes that there is going to be an emergency fencing and there is going to be a gate. So once the bridge is completed, all of the access, both commercial construction as well as the eventual residents of the property, will be accessing it off of Coley Davis Road, crossing the bridge, crossing the Harpeth there. And the only access at that point through the easement will be emergency vehicles. That was another point that the trial court relied upon, Your Honor.
So the trial court limited access even though the developer testified there was no limitation on access?
That wasn't the trial court that limited that access, Your Honor. That was Metro.
Okay, all right.
And it was just
Thank
part
you.
of the approval process in the rezoning.
So
That is
Metro did,
correct.
and the trial court took that, I assume?
Into account.
Okay.
Yes, sir. And again, that is, that emergency access only is in the record, volume 4, 530, 534, 535, and 536. At this point, I don't have any other statements unless the court has any questions.
I see none.
Thank you.
Thank you, members of the court. I do want to correct opposing counsel on one thing, because I do think it's important. Parole evidence was absolutely brought up in our reply at the summary judgment level at the trial court. It's page 4 of our reply. And we do believe that parole evidence is not appropriate here as to what's on the four corners of the plat. The plat identifies a 50-foot easement, but acknowledges that it is not a surveyed number because it is not in reliance on a title search. That title search was not there. If you go to the title search, there is a Harpeth valid utility ingress-egress easement for their equipment at that location. And so we think at a minimum that is an issue of fact for the trial to decide and not appropriate for summary judgment. As to the overburdening issue, I want to get back to footnote 8 in Judge Bennett's decision in Region. He says the degree and abruptness of the change of use of the dominant estate may indicate that the new use of the dominant estate is not normal development. These examples, and those examples are other things that are allowable by right within the existing zoning. And he says those examples may represent more drastic change in use than this instant case. And so what I put forward to this court is that in Region, the Court of Appeals said that things that are allowed within the existing zoning may be too intense to be normal development. Opposing counsel wants to say that anything that Metro grants is therefore normal development. It's cited in our briefs, but there is language in the Metro Code that expressly says when we rezone, we don't interfere with private easement rights. And that is a judicial determination as to overburdening. It is not for a local government body to say this is allowed on the property, and then we simply accept wholesale. If that is allowable on the property, it is a normal development, a logical expansion and extension of this easement. And this court has acknowledged that that's the case. And so I would proffer to you where that line is may be a fair level of debate. But when it requires not only a rezoning, but a change in the land use plan to even support that rezoning, that is beyond the line, and that is not normal development.
How did you go about proving overburdening in the trial court?
I think on our basis for summary judgment, it is the demonstrable proof of the rezone. There's no dispute that rezone occurred. And so if that is used in that upgraded zoning category, it is overburdened. That's our position for summary judgment.
You did not submit any additional evidence?
Well, no, we have testimony as to what was there before. There was discussion. I will say if we get into the parole evidence of Mr. Bolden's testimony, he does expressly say that he never intended it for heavy equipment. And as we know, the scope of an easement is what was intended by the original grantor. That is in the record. Mr. Bolden said this isn't intended for heavy equipment. You heard opposing counsel say we plan to use it for heavy equipment. So that alone supports overburdening if we get into the factual analysis of the level of use.
What I'm trying to do is understand what was before the trial court.
Yes, Your Honor.
What you're telling me is the mere fact, I say mere fact, the fact that the property was rezoned was the proof of the overburdening.
I believe it is, but I also believe that even if we get into the deeper analysis of the level of use, where Mr. Bolden said no heavy equipment was intended and heavy equipment is planned, that's there. And beyond that, it goes back to whether or not there are disputed facts. We have testimony from prior tenants as to their level of use that was much lower than what it appears this will be. And so that is all for a factual analysis at the trial court did not occur. There was affidavit testimony submitted as to what those levels were, and then we know the traffic study that was submitted with this rezoning for 417 units is much beyond that.
Did you attach that to your motion for summary judgment?
Yes, Your Honor. That's all. Those were all exhibits to the summary judgment motion.
Okay.
The rezoning package, testimony from those previous tenants. With my limited time, I just want to say that an easement by necessity requires that it was part of the same parcel that was divided, and that's not what the facts show here. So, thank you.
Well, at one point,
Yes, sir.
didn't one party own both parcels that's involved here?
No. There's been some suggestion of that by opposing counsel, but that is not, we certainly dispute the validity of that title search, and that was an unsupported document. So at a minimum, that's a contested fact, but we feel confident the answer is no.
Okay.
Thank you, counsel. We will take this matter under advisement, review the record, and attempt to get you an opinion at the earliest possible time. You may be excused. Thank you for your argument.